This helps me talk. Okay, hello Milltown. My name is KENNETH VERCAMMEN and I'm an attorney, so I'm here to answer people's questions and do things for about 25 minutes. So let me, I will put this timer on. That way, if I go too long, they can say, Kenny, shut up, we got stuff to do. We have to plant, tomatoes because it's after Mother's Day. Okay, so a lot of times people, believe it or not, New Jersey has reduced some of the taxes. So there used to be what's called a New Jersey estate tax. Everything over $675,000 was taxed. Just recently they did away with that. There's still a federal state tax, but that's only a few people here that have more than $15 million. Other than that, you don't need to worry about it. They also lowered the inheritance tax. So, the important thing though is to make sure that you have an up-to-date will and know where the original is at. So a photocopy can't be admitted to probate. An improperly signed will cannot be admitted to probate. So the surrogate says they have problems all the time where people try to get these free forms online, they fill it out wrong, and they've saved the $500 on hiring an attorney, but now they're costing their family thousands of dollars more because the surrogate says we can't do that. It's kind of like when I tried to do my own electrical work on my first house. I was we all remember the landlines, and I did all the landlines in different rooms. I was so proud. It was, I could do some electrical work. It's all color coded. Except in old Cape Cod where it's all just black wires. Well, I'm smart, I can figure it out, and then I almost burned down the house. So, try to do sometimes your own wills or powers of attorney, you're burning down your house. If there's no will or the will was not properly signed, that means that there has to be what's called an administration. What an administration is where someone in the family is petitioning the court to become the administrator, and becomes more complicated because let's say there's just 3 kids and they all agree this one should be the administrator. Still the other ones have to sign a formal renunciation in front of a notary and then pay a fee to have it filed with the surrogate. If one of them is the troublemaker, goes, no, I'm not going to sign that, I don't trust you, then the family has to go through the superior court and see good Judge Vignola, whose father was my first boss years ago, and becomes more complicated. Having a will done actually got even easier after probate. So the idea is you have your documents, and you don't want to cause stress, like if family's grieving. Okay, so did you have a question, young lady? Any questions? Okay, not yet. Thank you. So the idea is have your documents done. Don't put things off. When New Jersey had very high estate tax, our interview form was 6 pages long, asking about all questions about people's assets. Now I don't need to know about anyone's assets. I mean, unless they got more than 15 grand. That's why the interview form really just says what's your name. What's your address, who's executive 1, who's executive 2, who gets your stuff. We do ask if there's any real estate, because if someone has a house in other states, there's has to be a thing called ancillary probate, but it's that, in a way, it's that easy. What we also started doing during COVID was we would email the questionnaire out, and if someone says, I'm not good with computers, I goes, yeah, but your child or your grandkids go with computers, they can help you out, because most people are not doing secretive stuff where someone is being written out. But remember, it is your right to do with your assets what you want. Let's see, if you want to leave everything to the Yellow Dog Society, the Golden Retrievers, you can do that. Last year, a lady said, do I have to treat all my kids equally? I goes, yeah. I go, what's your concern? She goes, well, one of my sons lives on the West Coast. We don't hear much from him. Okay. Did you get a card or call on Mother's Day, your birthday, or Christmas? She says, no. Well, why would you leave anything to that bum? You know, I mean, like, you know, you didn't even call you on Mother's Day or whatever. You know, I remember one time I was in college, and it's Sunday in May, and I was, you know, working, because we're from Edison, my family wasn't rich, and I go, oh crap, it's Mother's Day, I gotta call my mom. So I grabbed the phone, the landline, and call her. Hi, Mom, happy Mother's Day. She goes, thank you, but Mother's Day's next week.
Oh, yeah.
Oh, good.
At least you were thinking about her.
Yeah, I was thinking, is today the day? You know, so it's your idea. And also, you don't want to have joint executors. It creates twice as much work. Someone goes, I got 2 kids, I want to treat them equal. That's good. They're going to get equal money. Executor one executor. Why create more work requiring 2 people to do stuff? So the will should also have clauses saying, listen, if someone passes, who gets their share? You know, kind of like going down. Okay, this person passes, who gets their share? If then there's none, a lady yesterday goes, yeah, everything's going to my husband, then to my child, then to my non-born grandchildren, but in case all 3 of us go in a plane, I wanted to go to my brother. Okay, fine, that's not that complicated.
How specific are you supposed to be with a will as far as leaving your assets?
We don't, the will doesn't list any assets at all.
It does not.
No. So the idea is that most people, whatever I have on the planet is going to this.
It doesn't have to be specified.
No, because we don't even put it in. You know,
Really?
because this gentleman said, you didn't list any of my assets. I said, I need you to email me the day you're going to die and what you own that day. And he goes, I don't know. I go, exactly. That's why, I go, you know, Mr. Shaw, everything's going to your wife, right? Yes. After that, it's going to your two children, right? Yes. Again, I don't need to know what your assets are. Whatever you have, I go, and remember, your goal is to spend as much as possible up to your, so you can enjoy your life.
But do you specify to specific individuals specific things, not just say,
Unless, there's a thing called specific bequests. People want money. You think that they might want your whatever, but they're going to bring it to Cash for Gold on Route 18 and say, what do you give me for this junk?
Yeah.
You know? My wife said, I'm going through the old jewelry box. This is the highest gold is. I'm getting rid of it, and you know, we'll spend it on our next trip. Yeah, you'll probably buy more jewelry on the next
right?
but you know, so now a will can have things such as specific bequests. Sometimes people say, listen, I want each of my grandkids to get 10 grand apiece. And by the way, more and more people are not leaving their money to their own kids, they're leaving it to their grandkids.
No.
Because their own kids already have a house, already grown, and they'll just do it on some luxury item. But they haven't really put away enough money sometimes for weddings or things like that that are kind of expected. I went to this college, University of Scranton. I was a runner, and I love Scranton. And one year I say to my wife, when our kids were younger, I goes, you know what? I think I'm good, and I was involved with alumni. I think I'm going to give Scranton $5 grand this year. She goes, yeah, how much have you put away for your own kids? Nothing. My wife, you're going to give a total stranger $5,000, and you haven't put a quarter into the account for your own kids. Well, you having said that, I guess Scranton is not getting $5,000. Amy, now you can also put in for charity. So what I did in my will, I said, okay, I mean, it's not a lot. I want $5,000 to go to the University of Scranton men's cross country team so they can buy better uniforms, and okay, I put $5,000 for my high school track team, same thing, so they can buy better uniforms, because you know, St. Thomas, Catholic school don't got a lot of money, and something for someone else. We support charities, but I tell people, don't leave a percentage to a charity. Whenever, unless it's 100%.
No.
Whenever a charity is named, there's a law statute that the Attorney General has to be notified. If this charity is not getting a set amount, then the Attorney General requires a formal accounting, and we had a case where the cost of the formal accounting to be sent to the Attorney General was more than what this charity was even getting.
Wow.
It was 1%. The charity couldn't say, listen, we waive the accounting, just give us the $7,000 and we're done.
Wow.
So, you know, that's why instead of saying I leave 1% to, you know, Saint whatever, you know, you could put down a set amount if my estate is more than X%. So there's also something that we call it the reverse specific bequest. It is I leave nothing to a name a person. There's not a reason. There's not, you know, not a dollar. Nothing to them. They know why.
Yeah.
You know, Grandma, I'm doing a new will. Okay, what's the change? My grandson hasn't called me in 4 years. He lives 2 towns over. You know, obviously he doesn't want the money or need the money or need me. Okay, fine. So nothing to. Also, we try to put in a clause that's not in some of these cheap free things online that says if anyone's under 21, it gets held in what's called a testamentary trust until they're over 21. But the money can be used for college or for whatever the executor deems as appropriate. You know, so, because otherwise, 18 is the age of majority, and someone gets money the day they turn 18. And 18-year-olds don't do smart things with money. I mean, maybe you guys did when you were 18, but I would have bought a red fast car. I was talking to a gentleman the other day. I said, your children are minors. We're going to have what's called a testamentary trust where they don't get any money until they're 22, 25, 30. If the money's needed sooner for college, for grad school, for a wedding, it's in the sole discretion of the person the family member you picked as the trustee. Because you don't want to trust a 19-year-old to say, in my best interest is to go to Maloof and buy a $200,000 sports car, because that's what they would sell you.
Sure.
Hey, there's only one left. Oh, the other person's looking at it. You better put a bid on it right now. You know, if young people get money, they'll go to Seaside and buy beer. Also, there was a change in the law some years ago for what's called to recommend a self-proving will. Under the old law, the person signed to 2 witnesses. But then one of the 2 witnesses had to either go to court or sign an affidavit saying, a notarized affidavit, that they were the witness and they were present. And sometimes, you know, in my grandma's estate, the witness said, oh, I was the witness in that law office, my fee is $500. My dad goes, we're not paying you $500. So the lady goes, well, get the other witness. Well, she's dead. Yeah, my fee's $500. We could have said, screw you, but then we would have had to spend $3-4 grand going to court and dragging it out. So by having a self-proving will, and I just mentioned that because just like the surrogate gave a talk with us, the cheap forms online don't say, you know, doesn't mention self-proving will, and then the family has to go find witnesses down the road, which could be strangers. We also, one of the things we do ask is anyone receiving currently or going to receive disability benefits, SSI, SDD? Because as much as you care about children or grandkids, you don't want to leave them money, and then the federal government says, okay, now we're cutting you off from your disability payments. So we kind of need to know that ahead of time. Okay. After you sign your will, it got to be in a place where people can get to it. Don't put it in a safe deposit box because people can't get to that. If you don't have a will, get one done. Easy enough. Do not be a putter offer. Don't be like Carl. So this guy Carl was this retired engineer. He used to go to all the Edison council meetings, put his suit on, and talk about how high the taxes were. But no one knew that Carl had a couple $1 million in assets. Carl was not wanting, But yeah, he liked to go, but they made him important. So he talks to me a couple times about the will, and he goes, okay, there was a time when you had the estate tax. And he goes, okay, we should do this. He goes, I want to read up on it. He goes, Carl, listen, you don't need to read up on anything. I went to law school, I passed the bar, I lecture on this, I go to other lectures. I want to read, it's like, you don't need to, I said to him, when I had my knee surgery, I didn't ask anything about how the doctor was going to do it. Dr. Hosey, have you done this before? It was Kenny. I'm the Rutgers team doctor. I could do this in my sleep almost, with my eyes closed. Okay. Don't hear back from Carl. 2 years later, his daughter calls. Carl passed away the way of his will. Nah, he kept on wanting to read it. He put it off. Get your stuff done. Don't be a putter-offer. Where's your original will at? If you can't find your original will in 10 days, I tell people, go get a new one. If you can't find it, your family can't find it. And don't have the filing system my wife used to have. Okay, this cardboard box is full. Let's start a new one. At least buy a fireproof box and throw it into the bed. Now, you could have the best will on the planet, but there are certain assets that go direct, and the will can't change that. So, for example, if a house is owned husband and wife, automatically goes to the survivor. The will can't change that. If someone has assets like a CD or bank accounts or IRA 401k that says pay upon death to this person or it's joint account, automatically goes to that person. Now, what we do recommend is have get from those companies the 2-page printout saying beneficiary 1 and secondary beneficiary, and you just fold it up and you put it with your will. Last month I was on News 12 New Jersey, and it was about life insurance with a beneficiary. MetLife took over, because sometimes with people's work they have life insurance, so MetLife takes it over. The man dies, they pay the money to his widow. But he filled out the form that said his 2 kids were the beneficiaries. It was a second marriage, and he met the lady 2 years ago. He wanted his kids together. So the story went to News 12 New Jersey's MetLife, the insurance company, say, well, you have to get the money from the other person. We already paid out the money. When I was talking to News 12 New Jersey, I goes, BS, that the insurance company got to pay out to the beneficiary. The fact that they screwed it up, they got to go chase those other people. It's not up to the next of kin. So it's a good idea, as I said, to get those little printouts. So we've already said, Executor 1 and Executor 2. Some people have set up, some of their times their kids are wayward and would blow all the money in the first year. So sometimes they'll set up a testamentary trust within the will for an adult child. But again, it's not that complicated to get stuff done. Now let's talk about what everyone asks me all the time. My mother-in-law she's 90 plus years old, still around, and she used to call me every other year. I want to come in and get a trust done. I want a revocable trust. And I say to her, were you watching Susie Orman on TV? And she said, yes. I go, Susie Orman is right if you live in New York, California, Florida, where the probate process takes 3 years and costs $15 grand. New Jersey probate costs $190, and the surrogate who has no say in the matter says people don't need to spend these $5,000–6,000 setting up fancy revocable trusts. A revocable trust doesn't protect assets from taxes. It doesn't protect assets from nursing home. The only thing, quote, is it avoids probate, but probate in New Jersey is easy. They did away with the estate tax, so no need to spend those high fees. Other people say, I want to have one of those fancy irrevocable trusts in case I have to go into nursing home. I said, okay. The attorneys I know that do that are going to charge you 12 to 15 grand up front. As soon as you want to spend that kind of money, I'll give you their names, but they're not going to give you a free consult, and that's what you know ahead of time. why do they charge so much? Well, the federal law has become very complicated, but 12, 15 grand is the cost almost for 1 month of nursing home. A lady brings in her mom one time and, mom wants to protect her assets. Mom didn't care. The daughter wanted to preserve her inheritance. Oh yeah, this ain't my first step. I go, all right, I go to the daughter. I goes, well, why don't you buy long-term care insurance for your mom if you're that concerned?
No.
I don't want to spend my money. And then the daughter says, what did I do? Oh, me? I'm not to be eligible, you have to transfer away all your assets. You can't be the trustee, you can't be in control, and it's a forever. And frankly, I'm not going to trust someone who ain't me to determine who's going to be in whatever facility. Your family might say, we can save money by sending them to the nursing home in Alabama.
That's right.
I want to go into the most expensive nursing home that exists. If I'm not sick and ill, that I can't lift up a spoon and feed myself, I want to go to the best one where it's the best care and the people are well paid, not the welfare one. That's me. Everyone here has been working since they were 13 years old. Let's see, I remember delivering newspapers in the rain on the bicycle. Sunday mornings in December, the newspaper was this thick, and I'd have to sometimes go back and because the newspapers wouldn't all fit on the bike, and so I've been cutting grit. I go, I wasn't killing myself so that my son, Dr. Brennan, can have a bigger boat, and I'm a crappy nursing. I mean, that's kind of just my little thoughts. Okay, let's talk about the power of attorney. Your will takes care of your assets if you pass away. The power of attorney is a document where while you're alive, you're giving the power to someone you trust to be able to make sure your bills are paid and act on your behalf legally. Let's see. Why would I need a power of attorney? I'm pretty fit, ran a mile this morning, I went to the pool and swam. Well, I can't pick the day that some dumb kid is looking at their phone and goes to the red light and creams the side of my car. Let's see, people that are Olympic athletes have like heart attacks and strokes. I mean, you don't know. So the idea is that you're giving the power to someone now in the event that something happens where you can't sign checks or do stuff. Let's see, once a week or every other week, we get a call. I need to get power over mom, dad, my brother. I goes through a power of attorney. He goes, nope, can't do it. You can't get a power of attorney over someone else. They have to affirmatively give it to you. Can they talk to us over the phone, and can they talk? Can they sign? If the answer is no, well, then you waited too long. You got to go through this expensive guardianship in the Superior Court, and then you got to go and it takes a month and a half, costs $5,000. You still get to see good Judge Vignola. Well, if it's done right, usually not. The idea is that most guardians, I'm a court-appointed guardian in some cases, and most of them, and once the report comes in, because they kind of they used to always 100% of the time require a hearing, and if it's pretty obvious, the court will say, "Listen, we'll waive the hearing and do it on the papers." My very first one, I said, "Here's pictures of this house." I was afraid to walk on the floor because I thought that we were going to fall through. It's 100 whatever years old and hasn't been anything, so the person obviously needs a guardian because she ain't taken care of. Now, power of attorney, a will is good forever, but because there's a statute that says that. Also, if you move to another state, the will is still valid there. However, there's no statute on the power of attorney. So we usually recommend a new power of attorney be signed every 5 years.
What about wills? How
will's
often
good
do you
forever.
think? But how often do you think, I've heard that wills should be updated after so many years?
Yeah, well, what we usually do is we tell people, okay, in 5 years, open it up, and can the people who you picked as your executors still do the job? Our rule of thumb on the executor is, can they drive to, well, used to be, the surrogate prefers now people come in with the documents. Can they drive to New Brunswick? Can they do the circular parking deck that within a week of it opening, you could see all these like smash marks on the wall, circle. And then take the elevator down, then walk up the hill, because there's no that's where the handicap parking is, in that deck. Can the person who your executor, can they drive to a bank and do banking? If they don't drive, it's not that we're non-drivers, we're practical. That's why motor vehicles doesn't let people drive that are blind or have epilepsy.
So someone 100 years old is not a perfect executor. Is that what you're saying?
Well, some people are fitter than others. So and just like, we look at the people that they need a walker to get around, but they're trying to drive. Oh, I only drive to ShopRite. If your reflexes are gone,
ShopRite is bad enough.
But it is what it is. Okay, the last document I want to talk about is the Living Will Advance Directive. Now, that's the people remember from 30 plus years ago, the Karen Ann Quinlan case, and the idea that someone shouldn't be kind of forced to be kept alive. So that's a document where most people are saying, listen, if I'm in a coma, I'm unconscious, I can no longer talk, and there's no possibility of me ever opening my eyes and enjoying life again, then I don't want to be kept alive through machines and tubes and respirators. When they first had the Living Will statute, people were afraid to sign it because their theory was, well, that means that, no efforts, if I have a heart attack, they'll just not try to resuscitate me. He goes, no, it's towards the end. If you have a heart attack, if you're buying grapes at ShopRite, they're going to do what they should do. I said, listen, let's see. If I have,
Thanks again.
some kind of, if I have a brain tumor or if I have Lou Gehrig's disease and, the doctors say, there's so I don't want to be kept alive through machines and things like that. Now, lastly, not a legal document, but many people do what's called the letter of last instruction, or just they write out notes for their family as kind of guidance. So I was at a wake for someone, and I go to the place in Metuch and both Boylan's or the other Irish place, and I go, hey, let me have your price list, and I circled cheapest cremation, because this way I didn't want my family to have to be shamed into getting the more expensive stuff. Because I remember one time they bring it into the casket room, and the first one is like mahogany with gold on the side. And he goes, I would feel bad if all my newspaper money went towards junk. My sister and I both wrote up letters of instruction. I call it, for my death party, where it goes, I want you to rent out the Edison Elks. I want to have an open bar, subs from Craig's Deli, and I already got permission to bring in yellow lab dogs there, because the dogs are happy and wagging their tails. And,
Did you put that in your will?
it doesn't go in the will.
It doesn't.
Goes kind of in the letter of instruction. Part of the reason why is because there's a statute that deals with funeral agent, and but the will can't be admitted for 8 days. So, I said, we want to have something that's fun, okay? Yeah, I told my wife, if you want to do a sad Catholic mass, you can do it afterwards. Have the party first. Not all the sad stuff. All right. So I have officially I have went past my typical